Millions of people slip and fall every year and require emergency treatment. Under certain conditions, these incidents can lead to legal actions typically known as slip and fall cases. These cases usually fall into the broader category of premises liability cases because the person who owns the property can be held legally responsible for accidents that occur on the property. Slip and fall cases can go to trial, or the parties can also avoid trial by reaching a settlement through lawyers or another third-party mediator. Prepare your evidence and establish your case if you seek to win a slip and fall settlement from an accident and injury. Documenting the fall. Understand the burden of proof. Determining whether the property owner is at fault for your slip and fall is an individual determination that will not rest on the same evidence in every case. Generally, the court will look at whether the property owner acted carefully so that slipping or tripping was not likely to happen, whether you caused your own fall by not seeing the condition or hazard that caused the fall when you should have seen it, whether the property owner knew about the dangerous condition that caused your slip and fall either by causing it or negligently failing to fix it, whether the dangerous condition existed for a length of time where the property owner had reasonable time to fix it. Note whether the accident happened on commercial or residential property. If you fall at a business, you must prove that the owner of the property or an employee of the business caused the unsafe condition, did nothing about it despite knowledge of the condition, or should have reasonably known of the dangerous surface. Proving that the owner or employee should have known about the dangerous condition is difficult because the judge or jury deciding your case will decide. The question that the judge or jury will ask is whether or not a reasonable, average or normal person would have discovered the dangerous condition fixed it upon discovery. If you slipped or fell at a residence, the landlord or owner may be held liable if you show that the person had control over the dangerous condition, repairing the dangerous condition would not have been unreasonably expensive or difficult, that a serious injury was the foreseeable consequence of the condition, and that the owner or landlord's failure to take reasonable steps to avoid an accident caused your slip and fall injury. Note the circumstances surrounding the accident. If you believe that the owner of the premises where you fell caused your injury, write down what happened right after the accident while it's still fresh in your mind. This information should include any visible defects in the surface where you fell, whether warning signs were present, and any contributing weather conditions. Torn carpeting. Changes in flooring levels. Poor lighting. Poorly maintained railings on stairs. Cracked or broken sidewalks. Narrow stairs. Wet or icy flooring. Document the shoes and clothing worn at the time. If you do not have evidence about the shoes and clothes that you were wearing, the owner of the property could attempt to place the blame for your fall on you. Keep the clothing and shoes aside. Do not wear them until after you have settled your case if possible. Write down the reaction of the owner, employees when you fell. If a representative of the business offered to pay medical expenses or even admitted fault by way